Hello, wonderful people. How are you doing? Hope you're good. Hope you're fine. How is everything going? Uh, this is Lawyers Info Hub. I'm your host, Mercy. It's another beautiful time to share legal knowledge to you. If you're a returning subscriber, I appreciate you. Thank you for always stopping by to know what is new on my channel. And if you're new here, please do hit the subscribe button, share this video, like it, drop your comment, and it will get response where necessary. So today we're looking at computer generated evidence and its admissibility. Yeah, we just hope, and I hope that you enjoy the class. As it's something a lot of people are are not so knowledgeable about, and I hope this video will help people out there, lawyers out there, law students out there, to understand computer generated evidence and how it can be admissible in court. Now, before the enactment of the Evidence Act of 2011, there was a lot of confusion, or there were different opinions on admissibility of computer generated evidence. So a lot of people were of the view that there should be a separate provision that regulates the admissibility of computer generated evidence rather than plucking it under several sections. So the opinions were sharply divided. Some people were, the older Evidence Act can work. Some people said, no, we need a new Evidence Act that will provide exclusively for um, admissibility of a computer generated evidence or document. Now, in 2011, during the Sixth Assembly in Nigeria, uh, they enacted the Evidence Act of 2011. Then there was Section 84, it talks about Section 84 that talks about how a computer generated evidence can be admitted. It provides for the admissibility of a statement contained in a document produced by a computer. Now, Section 84, sub 2 now specifically states four conditions to be fulfilled to render the electronically generated evidence or document, admissible. Why Section 84, sub 4, mandates the presentation of a certificate of authentication. Since that 2011, a lot of courts have made pronouncements on the way uh, to go about it, and where it involved different forms of electronic generated uh, documents. Now we're going to look through the cases and see what the courts have heard on how to tender, or to admit for computer generated evidence or document to be admissible. Now, the first case we're going to look at is the locus classicus. Is the local is a case of Kubo and another against Dixon. Kubo and another against Dixon. It's a 2013 for Nigerian Weekly Law Report, part 1345 at 534. Now, we're going to just look at some of the principles enunciated by the court. Now, one of the principles here is that a party that seeks to tender evidence of a computer generated document must lay proper foundation to establish the conditions set out in sections 84, sub 2 of the Evidence Act of 2011. Now, where the preconditions laid down in section 84 sub 2 are not fulfilled, such computer generated documents are inadmissible. This Kubo and Dixon was classical in the sense that it was one of those foremost cases that brought to light, or brought to light the provisions of section 84 of the Evidence Act 2011 as amended. Now, the second case we're going to look at is the case of Omishiro and another against Aggregate and another. Omishiro and another against Aggregate and others is 2015 15 Nigerian Weekly Law Report, part 1482 at 205. Now, in Omishiro's case, some of the principles uh, that was stated or that was brought out are, um, first of all, that it is not only internet generated documents that are caught up by the admissibility requirement, that uh it's not only the internet generated documents that are caught up by the admissibility requirement of section 84 of the evidence act, but all computer generated documents, your WhatsApp messages, text messages, and all of that, for the fact it is produced you know through the computer, and the definition of a computer is also key in this instance. Now, computer generated documents can only be admissible in evidence upon compliance with the requirements of Section 84 of the Evidence Act. These were one of the some of the principles that was brought out in Omishiro's case. Another principle there is that documents which merely have CTC stamps bearing engraved signatures on them without the subscription of the name and official title of the officer who certified them are not properly certified with conformity with the mandatory provisions of Section 104. What this one of another principle enunciated in Omishiro's case is the fact that when you're tendering a certified true copy of a document or a public document, we ought to be certified. And you have certified it and you're tendering it to court. It's saying beyond having that seed on it, CTC or certified true copy, there should be a subscription of the name of the officer who certified it, the official title of the name of the officer. The name of the officer and the official title is very important. And that if it's not there, then it is not properly certified in conformity with the mandatory provisions of Section 104 of the Evidence Act. Now, another case we're going to look at is um, the case of Akeredolu against Mimiko, Akeredolu against Mimiko and others. Akeredolu against Mimiko and others is a 2013 Law Pavilion Electronic Law Report 2532. The principle that was enunciated or that was laid down in that case is that a party is an election matter. They said a party who is desirous of demonstrating electronically the content of an electronic gadget or computer must lay the necessary foundation regarding the conditions of such electronic gadget or computer spelled out in section 84. What the principle is trying to say is that peradventure you want to tender a CD or a DVD and or you want to tender, like just for use maybe in the election, the card reader. You must show, I'm using this as an example, that that card reader was working well and that it was used in the course of official transactions or it has been in use and has been working well before you used it. You must lay the foundation regarding the condition. The court must know, was this electronic gadget in good shape? Was it functioning? Was it functional? So a party who wants to of demonstrating electronically the content of an electronic document. Maybe we want to show that the card reader wasn't working. I'm using this as an example. You have to prove it that this gadget was not functional as at that time or wasn't even functional. So you show the court that, my lord, this is how it's supposed to work and it's not working that way. So that case is very good, a very classical tool that is saying that a party who is desirous of demonstrating electronically the content of an electronic gadget must lay or computer must lay the necessary foundation regarding the conditions of such electronic gadget. You must show that it's working well or it's not working well. As spelled out in section 84. You understand in section 84, you have to show it in your certificate of identification that this computer was used or whatever you use is regularly used in the office transactions or in the course of maybe wherever you are or your office work that you usually use it. God has to know that it is functional, not just something that is not functioning. So that is about that case of Akeredolu and Mimiko. Akeredolu and Mimiko. I've given the citation. So another case we're going to look at is Carlo and another against Ohuabunwa. and another. Carlo and another against Uhuabu and another. Um, so 2015 Law Pavilion Electronic Law Report 25700. 25700. Yeah. Carlo against Uhu Abonwa. Now, the principle that was enunciated in that case is that Section 84, Sub 1 and 2 provides elaborate guide on how to treat electronically generated documents, whether they are or they are not public documents. So that case also reiterated that on the concept of certification too. That case also made mention that every public officer that has custody of a public document should make it available upon request by a person who wants to use that document after the payment of the subscribed fee. And the fact that the officer should certify that uh, document which confirms it is the original in the custody of the public officer, stating his name, his designation, as earlier stated in the other case of Mimiko. So um, another thing that the one of the another principle illustrated there is that the law does not require a public officer who keeps custody of a document to be the one to tender it. It must not be that public officer who certified that document that must tender it. For the fact it's the public officer who certified the document, he can give it to the person who needs to use it to certify it. The fact that the name of the public officer, his title must be on that certification, but in line with Section 104 of the Evidence Act. So that is some of the principles that were enunciated in Carlo against Uhuaponwa and another. So we're going to look at another case is Adeyela. Adeyela and another against Safiriyu. Adeleya and another against Safiriyu and others in the 2015 case Law Pavilion Electronic Law Report 41782, Court of Appeal. One of the principles and that was laid down in that case is the fact that the conditions stipulated in Section 84, Sub 2 of the Evidence Act for the application of Section 84, Sub 1 could only be fulfilled with some sort of foundational evidence by a witness in the witness box. What this principle is trying to say is that when your witness is in the witness box, I want to tender electronic document, electronic evidence. The witness should lay foundation on the fact that this document, I printed it out from so, or this computer, I printed it from my computer before you now, present the certificate of identification and tender it together with the document. Now, the principle too that was laid down in that case of Adelia is that a certificate that accompanying the production of a certified true copy of a smart card reader report sought to be tendered from the bar rather than the witness but could not have adequately fulfilled the contemplation of the conditions laid down in sections 84 sub 2 of the Evidence Act for the purposes of section 84.1. What that principle is trying to say is that, when you tender a document from the bar, a computer generated evidence, and its witness did not lay down this sort of foundational evidence as to this document is a computer generated evidence and this is how it was printed before we attach the certificate. The court said it couldn't have adequately fulfilled the provisions or the contemplations laid down in section 84 sub 2. Now, we also have the case of PDP, People's Democratic Party, and others against Abiodun and others. It's a 2015 electronic law pavilion electronic law report. The principle there is that not only internet generated documents that are cut off by admissibility requirements of Section 84 of the Evidence Act, but any document produced from any device for storing and processing information. That case also discussed who is an expert. That an expert is the person who, through education or experience, have developed skill or knowledge in a particular subject. And the fact that it's not only internet generated documents that are cut off with the admissibility requirement of Section 84, but any document that is produced from a device that is used for storage and processing of information. Another beautiful case where we can look at is that you can use in your intending documents in court in respect to electronic generated document is Lanlehi and Akimbi against Akimbi and others. Is a 2015 Law Pavilion Electronic Law Report 42147. The principle there is that any device used for storing and processing information forms part of the definition of computer within the contemplation of Section 258 sub 1 of the Evidence Act. Now, again, it's also reiterated that not only internet generated documents are caught up by the admissibility requirement of Section 84. So, not only internet generated documents, issue of text message and other small internet. You know that it's a computer generated evidence, that the fact is not internet generated doesn't mean it will not fulfill the provisions of section 84. So friends, section 84 is the main provision of the main provision in this evidence act that talk about how to admit a computer generated evidence. The fact it has to satisfy all those provisions and conditions laid down there, and also the fact that to attach a certificate of identification. In attaching a certificate of identification is the witness who is going to tender the document that has to, state in his name. It's more like an affidavit, though it is in just a one-page document saying, I, so person of so address, that I printed this document through so. So you have to list the description of, is it a printer, a computer, this type of computer, this type of printer, you list it and you print and you ensure that this computer has been in usage. And it's in section 84, you just ensure that all those conditions listed is in your certificate and you tender it to the witness and it will go in. So friends, I feel we've learned something today. These cases, you can go back, read them and understand properly what the law is. Read them. I couldn't explain, it's more than 1 hour. So friends, just take care of yourself and I know you've learned something today that will be of help to you. Thank you.